Uh, Briefly, my background, again, I'm Mark Bassingthwaighte. I'm an attorney, but I have been in the role of risk manager here with Alps for now 19 years. That's amazing how fast it's gone. Really, my job, I'm not a traditional lawyer, obviously. I was in practice prior to coming to Alps, but my job is sort of the proactive side. I am to educate, consult, those kinds of things. I answer lots of questions on the phone and while on the road. I've put just some of the practical kinds of things that we have to deal with day to day in three separate programs that we're going to kind of go through today. So we're going to start with just looking at some of the basics of malpractice insurance. Then we'll get into a little bit of risk management, sort of malpractice avoidance basics. And finally, we'll touch on cybersecurity. There's just so much happening in that space. When I started this job, I never thought I'd be involved in cyber and technology to the degree that I am now. And really, that's probably over 50% of what I do anymore. It's just crazy kinds of stuff. But let's start with just some of the basics. And one other thing. I don't know if you've received them yet. Alan has them, but there are three sets of written materials. I encourage you to keep them. Look at them at your convenience. They go much more into depth than what I'm able to cover today, and they're just meant to be a resource. And if at any time down the road, whether you're in Alps or insured or not, if any of you have questions or concerns, please feel free to reach out at the end of each section. I'll give you some contact information again, but please feel free to reach out. You don't need to be an Alps insured to talk to me, in other words. Okay, buying a legal malpractice insurance policy. Let's look at some of the basics. One of the things that I do deal with from time to time, and I get this, why do I need to buy this? Really? And I hear all kinds of excuses. I don't want to do it. It's very, very expensive. And I got to tell you, I guess, well, for me, expensive is a relative term. I can share it's nothing like what doctors pay, those kinds of things. But, it certainly isn't $500. But premiums, it's going to vary depending on how much coverage you kind of buy, but we're talking about several $1,000s, not several tens of $1,000s in terms of an individual attorney or even an individual attorney in a firm of 10 attorneys. Each of them may pay in this range of $2,000, $4,000, $5,000, just depending on a number of things. So that's very much of a ballpark. I also hear things I can protect myself in other ways, and you do find lawyers play this game now and again in terms of how they hold assets and whatnot, trying to just preserve everything that they have. I also get this at times, if I ever get sued, I'll just declare bankruptcy to avoid the loss. Okay, good luck with that one. And you hear these things, having a policy invites claims. I just think that's naive. I also hear at times, I'm just going to self-insure. I can share in terms of, what these claims tend to cost. If there's any legitimacy in terms of it's not just a nuisance suit or something like that. If there's any credence to this thing at all, you can blow through $100,000 fast in defense costs. You'd be amazed at how quickly that bill rises. And I just don't see people, in terms of small firms in particular and solos, really living or walking the talk, if you will, on saving and self-insured. I just don't have the funds there. But from my perspective, when I think even about our ethical rules, I think these excuses, if you will, really miss the point. Aren't we to protect our clients if something goes wrong? Sometimes even good lawyers just make mistakes, or a paralegal makes a mistake, or there's a computer issue and a date's just not calendar or something. And think about it. If you were a client of a lawyer and your lawyer in a personal injury action, blew a statute date and, it's over, wouldn't you expect to be made whole again? So why buy it more and more? My response is it's just because it's the right thing to do in terms of taking care of our clients. Now, again, if and when a client or a claim arises, what would the fallout be? And let's kind of look at this just briefly. Some stats that I can share, it varies geographically and over time, but roughly, 4 to 5% of lawyers are sued every year. Now, please understand, a lot of these suits don't go anywhere, but, we still have to deal with them. Claims can easily take 6 to 24 months to resolve, and, we have some claims that have taken much, much, much longer than 24 months, although that's not that common, but in other words, there's just time here. And as I shared earlier, defense costs can hit $100,000 on a claim with any merit at all. So again, I start to think about, what are the odds? I'm just trying to encourage lawyers to look seriously at this. And why? Here's another statistic you might be interested. Coverage statistics, again, vary geographically and vary over time. But there are a number of jurisdictions in the country where the percent of lawyers that are uninsured runs between 30 and 50%. And so, again, I'm trying to help change that, not from the perspective of, how much money can helps make, but I really firmly believe, and it's the right thing to do, to take care of our clients, because sometimes, again, just things happen. So let's look a little bit about, what does a malpractice policy cover? And another thing that we really need to think about here is when do you buy this? The first thing to be aware of, these are claims made and reported policies. Now, I don't know how in depth you've gotten on these kinds of things in your education. Most insurance policies, when you think about, for instance, your car policy, that's an occurrence-based policy. In other words, if I have a policy that covers my car, at the time there's an accident, I have coverage for that accident. That model doesn't work for legal malpractice and this type of risk. It becomes a pricing nightmare because, in essence, you might have 20 or 30 or 40 active policies over a career, and it just becomes a pricing nightmare and all those kinds of things. So the insurance industry moved to the claims-made model. Now what that means is, at its most basic level, if we have a policy in force at the time a claim is made and reported, there would be coverage, assuming, it's a covered misstep in these kinds of things. Now, there's one other thing that we need to be aware of. Thinking about prior acts, in other words, if I have a mistake, I have a policy today, okay, and I make a mistake 5 years ago, but the claim is going to come up today. How do I know that I have coverage for that claim 5 years ago? Every time you buy a policy, there is something in here and carriers call these things different things, but it's a loss inclusion date. And sometimes certain carriers have what they call an attorney's retroactive coverage date. But these are dates that say, even though this policy is just in force for 1 year, we will cover claims that arise out of work done back to the loss inclusion date. And that could be 5, 10, 15, 20 years ago. Now that's conditioned. So I guess maybe when does the loss inclusion date start? So let's look at that. Because this kind of gets us to you can't buy coverage for past acts. If I go out and on the first day of setting up my shingle and becoming a solo and buy a malpractice policy, my loss inclusion date is going to be the same as the policy inception date. So it's going to start that very first day. And as long as I continue to buy a new policy every year, my loss inclusion date will stay that very first day I practiced. I started in practice, because that's the first day a policy went into force. Okay? Now, sometimes lawyers will wait because we can't afford it. That's the thinking anyway. And they'll wait for a year or so and say, okay, I've been in practice now 2 years. I'm making a little bit of money. I feel a little bit more secure. I'm going to buy my policy now. Carriers will sell you that policy. But then they'll say, well, I need that to go back for the past 2 years because I have been working hard and there could be, I don't know of it, I'm sorry, no one will sell that to you. So your loss inclusion date, you want that to be as early in your career as you can. Now, another mistake that will come up sometimes is we'll allow a gap to occur. We stop buying insurance for a little while, and there can be other reasons gaps occur, but let's just say after 3 years of practice, a gap, you just don't buy it for whatever reason, and you skip a year or so, and then you decide to buy again. Your loss inclusion date is going to move all the way up to when you first restart coverage. Okay, so I just want you to think about claims made and reported. So the policy has to be in place when a claim arises, and you can't buy coverage for past acts. Okay, so those are two key things. Now, one of the other things that's extremely important to think about and understand a nuance here, these policies only cover you for work done on behalf of a client of the named insured. Now, this can get a little funky in a solo, but let's just pretend all of us work at a four-man firm. If I moonlight on the side trying to pay off some of the law school debt, those kinds of things, and I make a mistake in moonlighting, most people sort of intuitively understand there wouldn't be coverage for that mistake. And the reason is that's not a client of the firm. So you need to think about when you have a policy, you are not covered for everything you do as a lawyer. You are only covered for everything you do in an attorney-client relationship, these kinds of things, on behalf of a client of the firm. Okay, so that is something you really, really need to just appreciate. That's created a lot of problems over the years. And again, just the final, a new policy must be purchased every year in order, again, to maintain this prior acts coverage that we've talked about, so that loss inclusion date, you never lose it. Even 20 years in practice, it'll go clear back 20 years ago if we have a policy every year going forward, just consistent. Okay?
Hey, Mark, I have a question.
Yes.
What happens if let's say I've got ALPS for the first 10 years,
right,
and I use the competitor for the next 5,
mm-hmm.
and I go back to ALPS in year 16?
As long as during the jump shifts to back and forth here, as long as there's not a gap created, the prior acts will continue through that whole process. If you will, the whole industry operates such that we honor each other's loss inclusion, prior acts. It just isn't an issue. In almost all situations, I mean, if your reason for jumping to a carrier after 10 years was because ALPS non-renewed you for breach of contract, you didn't pay your deductibles, or there's some kinds of something happened. The new carrier may say, I will insure you, but I'm not going to offer prior acts. And they have every right to do that. Now, that doesn't mean you lose everything. Your premium at the new carrier is going to be cheaper because they're not covering your prior acts. And you have then the possibility of looking at tail coverage so that you don't lose all of that prior act. And you would have to buy tail coverage from us or the other carrier if you're coming back to us, these kinds of things. So but short of some of these more unusual and just problematic situations, generally just moving for price, moving for, often it is just price. There are different types of coverage, a normal, if you will, transition. That's not an issue. We all honor each other's loss inclusion dates, and that's just standard in the industry. Does that answer the question for you?
Yeah, it does. A few years ago, we had ALPS, then we merged with a different group, and then they went to somebody else, and now we're back with ALPS again.
Okay. Uh-huh.
Yeah, that's because of a merger situation, because that happens.
Yes.
Firms merge, and somebody's got love for one carrier or another.
I have a couple of questions.
Go ahead.
So is there some sort of, you said they have to renew every year, is there some sort of inflation rate, or if you have any sort of claims, does it go up kind of like with car insurance? You get in an accident or speeding tickets and you inflate your price.
Well, okay, there's two things you're asking about, actually. When you first, okay, let's say that you start right after law school here, you hang up the shingle and it's just you, okay? Your premium is going to be very, very low for the amount of coverage that you're buying compared to, for instance, if I went back into practice, well, no, not me. If I've been in practice for the last 15 years and I'm buying the same amount of coverage. And the reason is you don't have any clients, okay?
I got 31 years, so.
There's this normal gradual increase in premium generally over the first 6 years of practice, where you need to expect your premium is going to increase every year, regardless of what company you're with, because you are maturing in terms of risk. Okay. Now, beyond that, if you have a claim, and there is, and this varies by carrier, but there's some type of loss and or defense cost. That's not just $1,000 to make something just disappear. Let's say a $50,000 loss. These kinds of things, you would be surcharged for a period of time. Now, some carriers surcharge the firm. Some carriers surcharge the attorney. In terms of the attorney's portion of the firm's premium. There are different ways that carriers do this, but is there going to be a premium increase after a loss? Yes, and that will be there for a period of time. Mm-hmm.
Okay, so I have two more questions for you.
Yes.
Is there different sort of insurance carriers or providers that are targeted towards particular practices?
Can you repeat that, please?
Are there particular carriers that are targeted towards specific practices? Or practice areas is probably a better way to say that.
I would have to say no, in the sense of, I'm not aware of insurance companies sitting out there and saying, we're only going to insure criminal law practices. Everybody wants criminal law practices because there's hardly any malpractice there. What you will find is some carriers will not write in certain jurisdictions or not write certain types of practices. So it's not that they're targeting, it's they're protecting themselves from. Okay. Real estate has been a huge problem on the East Coast, and many, I shouldn't say many, a number of carriers completely left the legal malpractice market entirely as a result of real estate losses in terms of lawyers messing up real estate transactions. Some lawyers will, or some firms are very hesitant to write intellectual property firms, and sometimes even plaintiff firms. So it's not that they're targeting, it's they're saying, we're not going to look here. Okay.
Yeah,
one other question, I thought?
That actually answered both the questions.
Okay.
Thank you.
All right. Going a little further here are some things that you need to understand about policies. Think about policy limits. Most of these policies have an individual per claim number and an aggregate. Now a base policy, and many companies don't even write this anymore because it's so low, 100,000. So it would mean I have 100,000 that I could available for a claim in any given year. And if I have 2 or 3 claims, it has to be divvied up. It's 100,000 no matter what happens. But you could buy 250,000, 500,000. So there I could have 2 claims come up, and each of them have 250,000. And if I don't have 250,000 spent on either claim, such that there's still 300,000 over, I've got that still sitting if a 3rd or 4th claim happens to come up. So understand some of those basics. My personal, in terms, I get asked a lot, how much is, what do I need to have? And there's not a magic answer here, particularly for young attorneys if they're starting out solos. Anything is better than nothing. But I really start to say that 250, 500 is more of a baseline. I start there, and it can go up fast depending on how long you're in practice and size of the firm and those kinds of things. One thing to be very sensitive to is this whole issue of defense costs. You can be comparing what you think are identical policies between two companies, but they're very, very different prices in terms of the equal limits. And often the reason is the cheap policy has defense costs inside limits and the expensive policy has it outside limits. When it's inside limits, what's happening is every dollar that you spend on defense is $1 less to have available for the loss. Okay, it's what we call a self-liquidating policy. That's why they're cheaper. You think you're buying $100,000 in insurance, but you really aren't, because as soon as defense is in, and so it creates some conflicts between what the carrier's wanting to do and what the lawyer's wanting to do. Outside limits is the better way to go, and they're going to be more expensive. But here you kind of get what you're paying for. Policies in terms of the specifics of this vary carrier to carrier, but generally you're going to have, for instance, with ALPS coverage, it's half of the policy limit, per claim limit is available for defense before the claim or the per claim limit starts to go. So let's say if I have a $500,000 per claim policy, I have $250,000 available on that claim as defense costs before they start taking money away from the per claim limit. Okay, now they can cap these things. If you have multiple claims, you don't necessarily get multiple 250,000. There are caps on it, the way that works, but it's a much, much better policy. You also want to look for first dollar defense, and in essence, what this is, there's a lot of claims that a little bit of defense can make them go away. In essence, we're kind of going to take your deductible off the table on anything but legitimate claims. So you don't pay anything toward a deductible unless and until there's a settlement or a judgment against you. So if there's an actual loss, then your deductible's in play. If there's not a loss, you don't have to pay your deductible. That can be significant. So something else just to look for in terms of shopping. Some exclusions, I just encourage you to read your policy. Carriers really differ in the exclusion language they have and where they place these exclusions. But some things to think about. One of the things that trips up a lot of lawyers is we exclude coverage for obligations that arise out of contract. And this is becoming more and more significant in how all these various business models coming up in terms of what lawyers are doing and projects are getting involved in. And basically, the issue is indemnification agreements. So if you work for a service or a client, there could be all kinds of ways indemnification agreements can come up. You are voluntarily expanding your obligations, your exposure, if you will. And the insurance carrier is not agreeing to that, is not a party to that. So if you're subject to an indemnification action at some point in your career, kind of good luck with that. That's the kind of thing to be aware of. We also don't cover investment advice. A lot of lawyers at times will give some investment advice to their clients. You should invest here, buy this, or whatever. And if that advice goes south, again, good luck with that. So we need to understand, these policies cover you for not negligence, for professional negligence only. Theft of funds would be another thing to be careful about. What are your obligations? You need to understand that as well. And one of the biggest is, when is the obligation to report a claim? When does that arise? And in almost every policy, it's not when you're served with papers. Think about it. If you were to blow a statute, and you don't want anybody to know, and lawyers, yes, do this more than you'd imagine. They're trying to make it go away, deal with it. They may even pay money out of their pocket and these kinds of things that are just make a bad situation worse. We know a claim is there. The circumstances of a claim are there. We know the misstep has occurred. You need to report it immediately. or when 6 months later, I've even had it go much longer than that, you finally are sued and you report it. The carrier says, breach of contract, no coverage. And sometimes they say, we're going to rescind coverage, which means you've lost prior acts for everything you've ever done up until this point. So don't mess around with reporting obligations. They are very, very significant and can make or break your financial life, literally. So again, just start to look and understand some of the basics of coverage. Just a couple of quick tips. Was there a question?
Yes.
Yes.
So, what is the difference between a policy for a younger attorney versus a senior attorney, more or less?
I just am having trouble hearing you a little bit. If you could speak louder, please.
Yeah, Mark, the question is, in terms of the premium cost, how much of, this is probably a little unfair, but how much difference is there between a young lawyer starting out, say, versus a lawyer that's been out for 30 years? In terms of, how much of a differential is there on premium?
In terms of premium?
Yeah.
You know, it depends a little bit on carriers in terms of how they underwrite. It's more difficult to answer than you might expect because, you know, for instance, an attorney who's been in practice for 30 years as a criminal defense lawyer is a very, very different risk than a personal injury plaintiff lawyer that's practicing in Las Vegas. You know, so all of the...
Someone in Idaho.
Well, in general, the premium, depending on limits and whatnot, you probably just first starting out, we're probably talking somewhere in this neighborhood of $1,000 to $1,500, somewhere in there. And again, I'm speaking for the industry. I can't, you know.
Oh, okay. And that's per year, right?
30 years into practice, if you've not had claims, and depending on practice area and geographic area and all these kinds of things come into play, but you're probably talking anywhere from $3,000 to $6,000 an attorney. There are just so many ways that this can go in different directions in terms of numbers. But, you know, once you hit, if you will, full maturity in that 6 to 7 year range, we don't continue to have this climb of premium because you're now 10 years or 15 or 20 years. Fully mature risk stays fully mature from 7 years on. And now all the other variables come into play. Okay?
Yeah, Mark, this is a totally just not scientific other than our policy. It's not changed a lot.
Yes.
In the last 5, 10 years. It's just not gone up much. It's stayed pretty steady.
Uh-huh.
And just to comment on the first dollar defense, this is personal observation.
Yes.
Lawyer's crazy not to buy it. Because
Yeah.
I ran the numbers, and it just takes one claim in 7 or 8 years, and it's paid for itself.
Yep.
Because the legal cost, it'll be $100,000 before you blink.
Oh, I know.
And the first
Yeah.
dollar coverage is just golden, absolutely golden.
Yep. Yep. Just a couple of quick tips about the application process, guys. I think it's worth having this discussion now because I don't want bad habits to form. You know, what we see at times, you just shake your head. Please understand, underwriting is an art, okay? So when you have an application or your portion of an application, if you are practicing at a firm, you're gonna be thorough and put your best foot forward. You mean, answer all the questions, and details matter. You know, you'll see sometimes on claim supplements, you know, well, in essence, what did you learn from the claim, or what have you done as a result of this claim? And the pat answer that comes back is, we fired the attorney that screwed up. That's not helping you. That's, you know, that's not what we want to know. We want to know, okay, how did the calendar go awry and what have you done to fix it? Neatness and timeliness counts. if it's a sloppy application and we're having trouble getting phone calls returned because we just need some additional information, or the application is returned literally the night before the policy is to expire, what are you telling us about attention to detail, client communications, how your files might look in terms of neatness and sloppiness and all that? You're telling us a lot about how you work, whether you realize that or not. Okay, so just think about that. To the degree you have the ability, depending on what your applications look like and your portion of it, et cetera, emphasize risk reduction practices. We do want to know, and I'll talk about calendaring in a bit, but we do want to know what you're doing for calendaring and conflict checking systems. Calendaring is the frequency piece. That's the number one source of claims. And conflict is the severity piece. It's not that there's a ton of them, but when you have a legitimate, if you will, conflict claim, real money is often involved to get these things resolved and make them go away. Because, they always boil down to greedy attorney putting his or her financial interests above a party, and juries have field days when it comes to punitives. So we want to, do you have a system? If it's memory only, that's not going to serve you well. We want to understand, what is the system that you have in place to check conflicts? What are you doing with file documentation? Again, I'll talk about this in detail in a minute, but it's looking at different types of closure letters, engagement documents, these kinds of things. We also want to know, do you sue for fees? Some carriers actually will not write a policy for any firm that sues for fees at all. They just won't do it. ALPS has a tolerance for us, and there are other carriers that do as well, but we want to understand what you're doing. If your bottom line is, I sue anybody that owes me money, I don't want the business, we don't want the business. That's not, I will, again, share some more in a little bit. But one of the biggest things here, never lie or try to hide anything. You must be truthful. For instance, let's go back to, well, I can't afford coverage right away, and so I am in the first year or so of my practice going bare, and okay, I'm going to run that risk, and all of a sudden, oh my gosh, I've made a mistake. So the first thing I do is pick up the phone and try to buy a policy to cover that loss. Well, you're going to be answering questions. Are you aware of anything that could lead to a claim? And it's kind of this reasonable attorney standard. And if you answer no, lying, and it turns out, and you'd be surprised how often we learn this, that you were lying, we get back to this rescission of coverage problem, and it can be a disaster. So, don't try to play that game. What the carrier will do is sometimes say, okay, so you made a mistake. We're going to exclude coverage for that. I hope that works out, but we'll cover you for everything else and get you going. Again, some coverage is better than none. And we're not afraid to insure lawyers or firms that have had a claims history. What we don't want are lawyers or firms that don't want to be better as a result of the experience. It's this stupid client's fault. We got rid of the bad actor attorney, these kinds of things. They want to wash their hands. I don't want to insure that firm. Okay? So if you have an opportunity to share how you are better as a result of the experience, you can do wonders in terms of the underwriting process. So that's a quick run through of malpractice coverage. Again, we'll start another slideshow here in just a minute, but here's a chance, particularly my email address, if you want to notate that for use down the road. mbass@alpsnet.com. Again, happy to try to help. So I need to.
Quick question, Mark.
Yes.
Maybe talk a little bit about tail coverage and how it works.
Okay. In what context? A jump?
Let's maybe the easiest. Let's say I've been practicing law. I have two questions, actually. First one is, I've been practicing 30 years and I'm going to retire.
Okay. Very
advise
brief.
the
Let's take the
coverage?
retirement first, okay? Very briefly, just to perk again on some policies, please understand that some carriers, if you remain insured with them for a period of time, 3 to 5 years, this kind of thing, in terms of the last 3 to 5 years of your practice, if you remain insured with the same carrier as a solo and only as a solo, and you fully retire, you can get a free tail. Now that can be a significant savings because a lifetime tail, again, carriers differ on the formula here, but figure roughly 300% of the last premium. That can be real money. So also understand that a tail is not a new policy. You're retiring. You're leaving the practice. Go on the bench and all kinds of things can happen here. It is an endorsement to the final policy that is in place. We call it an extended reporting endorsement. All you are doing is you're paying premium for the right to report a claim for a period of time going forward. A lifetime tail would be for your lifetime, under the terms and conditions of the final policy that was in place upon retirement. Okay? So a mistake a lot of lawyers make is they slow down. Again, I'm thinking about solos in particular here. As they slow down and start to go part-time, play a little golf or whatever it is, they say, I'm not doing as much, so I don't need limits quite as high. I'm going to try to save a little money the last 2 or 3 years. And so by the time they get to the final policy, it's 25 or 2.5, I'm sorry, 250,000, 250,000, something like that. But, oh, this is an estate planning guy, and he wants retirement. Oh, I want at least 1 million, 2 million. I'm sorry, we aren't going to sell you that because you're going to live, all you're doing, what we're selling is an endorsement to the final policy. So if you allowed your limits to decline to save some money, that could be a real misstep in the retirement piece. So something to think about. The other issue is the lateral move. This gets a little more complicated. Some carriers will not sell a tail to an attorney in a lateral move. And that isn't necessarily a problem because you have in policies what's called former attorney language. So if I leave our firm and we have an ALPS policy, under former attorney language, I would be covered for any claim that arises, as long as, again, the firm maintains coverage on a going forward basis. I'm not in control of my risk in that setting, and I understand that. But some carriers will not sell it. So you want to have that discussion, look and talk. I prefer getting tail coverage if necessary. But the other situation in terms of lateral, it also may not be necessary because the firm I am moving to, and the terms or carriers call these different things, but they may have a policy such that it picks up, and they've paid premium for this, it picks up the prior acts of lawyers coming in. And so that can be beneficial. You don't see that a ton because they don't want to buy, claims, but some firms do to just have talent come over. So that's a really short, does that get to your question?
Yeah, it does. It
Okay.
does. I have another question on volunteering on nonprofit boards.
Okay.
This is because it's come up more and more in the last roughly 10 years.
Uh-huh.
I'm on a board and we disclosed it helps on all of it, but to speak a little bit about, because both of my students here I know have got some interest in nonprofit work sometimes. And so if they're asked to be on a board, I know of a couple lawyers in town that have been told you may not be on any boards anymore for whatever reason.
Well, it's not as trouble-free as it used to be. There have been some substantial losses in this arena. There's some good news here in the sense that, and again, as you're looking at purchasing insurance down the road, these are the kinds of questions, if they are important to you, you want to ask and get answers to. Some carriers will provide no coverage in this situation at all. Others will provide some limited coverage. So you need to kind of look at the specifics of the policy. But one of the missteps that you see in this, the nonprofit wants an attorney to participate on the board, honestly, because they want a little free legal advice. Okay. The best way to do this is say, look, I get that. I don't want to create potential conflicts and start thinking about all the problems of wearing two hats at once in terms of attorney-client privilege. Am I acting as a director now and an attorney now, and these kinds of things. Just make it simple. Just volunteer to be their attorney and wear that hat and only that hat. But outside of that, some lawyers, like the prestige of it and all that. Okay, that's fine. What I would encourage you to think about is, again, earlier we talked about how coverage is only in play if you are doing work on behalf of a client of the named insured. And some attorneys and firms get very informal with this, and they may not even be aware that an attorney is sitting on a nonprofit board, and a claim comes up, and we got to call ALPS, and the firm says, what are you talking about? We had no idea you were sitting on this board. This isn't a client, and we're not calling ALPS. Or the carrier may say, okay, is this a client of the firm? And the firm will say, yes. And they'll say quite legitimately, well, would you turn over the file? Where's the documentation? And often this just isn't there. So my best advice is, if you're going to sit on a corporate board and occasionally do some work, please, with awareness and approval of the firm that you are at, document, the decision-making process. Document that this is a client, and keep a file here of the advice given and these kinds of things at the firm. So I'm just trying to help pin down coverage and sharing some of the mistakes that lawyers make. Does that answer your question?
It does, because, I know, myself included, I'm not on a board because I'm a lawyer. I'm there because of my understanding of financials and tax and all that. But I don't give advice even in that arena. I just make it very clear to them, I'm here because I care about kids, or I care about the church, or whatever.
Yeah.
And we always, whenever a legal question comes up, I defer to our corporate counsels. I don't.
Always the best way to go.
Yeah.
So how are you insured with family then? Because it's not, I don't know if you would necessarily count it as moonlighting when you're providing legal assistance to family, but then if a malpractice suit is brought against you by that particular family member which you provided those services, how would you be covered if you're working in a firm but they technically weren't a client of the firm?
Then you're not covered.
At all.
Because like Mark was saying, if set up a file in your firm for your family members,
Gotcha.
so they are a client of the firm. Because if you don't have any record of them ever being a firm client, then you're moonlighting naked.
Okay.
Yep.
Mark, is that a fair statement?
Yep.
Well, that sounds terrifying.
In my mind, moonlighting is always there. Okay? That's what I would encourage you to just keep in mind. Yeah. Yeah. Anything else?
I have a question. So right now that we are doing some practicing in a school, and I don't know if probably it's close to the question that Alan asked you. And we are working or helping pro bono. Who will be,
Like the clinics?
yeah.
Yeah, the law school has clinics.
Right.
They have a tax clinic,
And we have the business clinic.
the business clinic, and some of those things. So I guess it's more, how does that work when I've got a student
I
that's
made a mistake. I
Yeah.
made a mistake. What happens
in
with?
one of the clinics?
is
Well,
the-
in the student
Sure.
clinic section or situation, that can get a little funky, and I'm not sure that I can give you a great answer I can anticipate. Now, let me talk about pro bono in general.
Okay, thank you.
There are some
The passion's
organizations
there.
and entities that lawyers in varying capacities and at various points in their career participate in. So they are providing a legal service under the umbrella of this entity. Now, some states have statutes that provide, take care of that. You can't sue the lawyers in these settings, kinds of things. They're protected. Other states, these entities themselves go out and purchase coverage for all the lawyers that volunteer for the program. If it were me, I'm not going to do any pro bono under an umbrella of an entity absent that. The alternative is, if I pick up a client and I want to do some pro bono work, again, with firm awareness and approval and all these kinds of things, I'm going to make that, if coverage is a concern, I'm going to make that pro bono client a client of the firm. Because coverage is not dependent upon is there a fee agreement, is there money being exchanged? It's dependent upon is there an attorney-client relationship, and who under sort of what banner is the attorney-client relationship subject to? A firm, an entity, those kinds of things. Now that said, if you're participating in some limited scope kinds of things, general information, hotlines as an example, I don't really, to be honest with you, worry a whole lot about coverage because we're really not creating attorney-client relationships. We are answering hotlines and general questions and steering people. And sometimes our advice is simply, yes, you have a legitimate concern and I encourage you to get a lawyer, but
Well, no,
that's
but
my initial thought. Anything else?
well, the pro bono work that we do up here in the school is always supervised by an attorney.
Uh-huh.
We always have to have a attorney supervisor. So, do you think that they are the one liable if something happened?
Oh, yes.
Okay,
Absolutely.
okay.
Uh-huh. Yeah. I'm not worried for you as a student participating in these settings. I strongly encourage participation in them. I think they're very, very valuable.
Okay.
Yeah. I sort of look at you, and please understand, you're not a licensed attorney.
Liabilities walking.
Someone else is going to be responsible and accept be accountable for your work in that setting. Yes.